Hey, what's up, guys? Welcome to Lawsplaining the Interwebs, a show hosted by me, Nick Rekieta. I'm a lawyer in central Minnesota who has nothing to do with anything I'm ever talking about, so get over that quickly. What I'm going to do today is talk about this memo from Devin Nunes. Nunes, not Nunez. Who cares? He's a congressman on the House Permanent Select Committee on Intelligence. And this is a controversial memo release for a lot of reasons. But this details some aspects of the wiretapping that occurred on a Trump staffer by the name of Carter Page. Let's see. Where do I begin on this? Let me frame this properly. If you're looking for like a rah-rah confirmation bias praise of this memo release and a condemnation of all the evil things that were done by the Obama administration against Trump, this probably isn't the video for you. That's not to say that I think the memo is bad or I'm opposed to it or anything like that. But what I'm going to try and do is give an honest assessment of what has happened here. And I'm going to be fair as I can. And we're going to talk about kind of what goes into these FISA warrants, and we'll bring up the reality as far as we can, right? Because most of this stuff is classified. Thanks George Bush for really expanding the Foreign Intelligence Surveillance Court and through the Patriot Act, and like making this court that no one's allowed to know exists, and no one knows what judges are on it, or they may know now, but they couldn't until Snowden, right? Until Snowden went ahead and dumped a bunch of information about this court, then suddenly we're allowed to know because we already did. But again, remember, he's a criminal and a terrible human being for telling us all the stuff that our government does without us getting to know about it. But the FISA court, the FISA, Foreign Intelligence Surveillance Act, and the Foreign Intelligence Surveillance Court, I'm going to use them interchangeably because it's annoying trying to distinguish them. But the FISA court is this cool court where the government goes in and asks for something against, say, anybody, and they're not even allowed to know that it has occurred. And when the evidence comes out and is used against them, it's classified, and their ability to rebut this evidence is minimized in a couple ways. One, it's classified. Two, the way courts review things like warrants and the way courts review decisions is a lot different than how courts deal with things on the fly. If we're in an adversarial argument about, the guilt or innocence of someone, or even the admission of evidence, okay? So let's say, because most of this stuff we're talking about is later. So let's say the cops gather some evidence against a person, and then they're going through the pretrial process to determine if there's a trial. You have this preliminary hearing, which you get to challenge the sufficiency of evidence, which both sides get to come together and fight over whether the evidence is good or not. Well, the interesting thing with the FISA court is their decisions tend to be reviewed after the fact, so you don't get that preliminary fight. You often get a fight later in which a judge of sufficient jurisdiction is able to review a decision of the FISA court. And guess what? They always seem to side with the validity of the FISA court's decisions. It's amazing how when the government gets to present their side of the argument and you don't get an attorney to represent your side, the government seems to win at an alarming capacity. And I was going to do this second, but I think I'll do this first. Since 2015, they actually have finally been required, again, conveniently following Edward Snowden's release of documents and acquiring of pariah status, they passed legislation to force an accounting of FISA court processes, right, by year. Started in 2015, and I'm not going to go through this whole report. There's a summary. Who cares? You can find these reports online. They're not special or secret anymore. They were. And here's why. Here's why they were secret, okay? Look at this. So this is the most important part of the section for this, for this video. Here's Table 1. In accordance with the reporting requirements specified in 50 U.S.C. 1873 A1, the statistics in this table are itemized by section of the statute. So these are the applications by the FBI or some other investigative body to the FISA court for a specific type of warrant. And it's really not important, like, which each of these sections, what they pertain to for this video. Maybe at some point I'll go through and do a full FISA video. But I don't know if there's a point because, you know, it's only a court that issues Supreme Court level decisions without another party involved to fight for the rights of Americans. So it's only like entirely the opposite of the constitutional mandate for the judiciary. It's entirely the opposite of everything that our country was founded on. And it looks a whole lot like some of the secret courts that were held by monarchies that the founders were trying to escape. But, you know, it's fine because we've been around for a couple hundred years now, so we can go ahead and go back to all those bad things. But anyway, let's look at these numbers. So Section 1805, 80 applications. Orders granted, 57. Orders modified, 23. Applications or certifications denied, 0. 0. I can't select it individually. It doesn't matter. These modified orders, that means they required some modifications. They made the modifications and granted the order. 1824 only. Okay, well, I guess real quick. 1805 are electronic surveillance only. 1824 are physical surveillance only. And then 1805 and 1824 applications are where both of them are combined. This is the most common type because they want to have the ability to do a physical search also if they need to. Okay, so anyway, 1824, 23 applications, 17 granted, 6 modified, 0 denied. The combined applications, 754, 623 granted, 126 modified, 5 denied. There you go, 5. 40 applications, 33 granted, 7 modified, 0. 68, 61, 7, 0. 1881A is classified, so we can't know how many applications were given, granted, modified, or denied. They just don't tell us. 1881B, 0 applications. 1881C, 45 and 45 granted. So, running total, roughly what? You got 750, 800, 900, about 1,000, right? And 5 were denied. So 0.5% were denied. That's a pretty good denial rate. Let's see what happened in 2016. Same table. It's right here. Oh, look, they requested a lot more stuff. 105 applications, 61 granted, 39 modified. Oh, this one denied 5 in part. So part of the surveillance was denied. Who knows what part? We'll never know. They're classified. 42 applications, 28 granted, 11 modified, 3 denied in part. Notice none of these were denied totally. 1338 total for the combined. 1,052 granted, 260 modified, 18 denied in part, 8 denied. 60, 50, 10, 0 denied in part, 0 denied. 125, 108, 16, 0, 1 denied. 1881A again is classified. 1881B seems to be useless. None were even asked. And 1881C, 82, 79 granted, 3 modified, 0 denied. So you've got 9 denials out of, 16, 17, 1800. So again, you're looking at roughly 0.5% denial rating. That's to give you an idea. As we start to go through this, you know what? I want to frame this as in 2 ways. One, when the Nunes Memo, when that memo lays out that they basically wanted this application denied, right? Like that's the whole idea here, is you want to deny the application, or you wanted the FISA court to deny the application, and you're saying the FISA court would have denied the application if it had known that the information they were looking at was based on these things. Look at those denial numbers. It's a 0.5% chance that they'll deny anything. Just at a raw statistical look. It's a 0.5% chance. Would they have denied it? I don't know. But to come out and say that they would have denied it had they known this stuff is a bold, bold claim. And the nature of this thing, right? The applications are classified. We don't get to see what other information they have. We have to take Nunes at his word that it was based, almost solely on the Steele dossier, and that if they'd, been informed of the source of the Steele dossier, that it would have been denied. Strong claim. I don't 100% agree, mainly because, now listen, I don't agree because the FISA court is garbage, okay? It's a sham. It's a joke process with a joke procedure. There's no public oversight of court proceedings against American citizens, and that's ridiculous. It's ridiculous. Everything is classified and for national security purposes, and it allows a court a rubber stamp. That's the big criticism of the FISA court. It's the criticism ever since it was made public, is that this is a rubber stamp factory for surveillance. It provides warrants for surveillance, but those warrants are meaningless. They're pointless words on paper because they don't follow the traditional warrant process. There's very little review and oversight. They're never overturned, and they're always approved. So, sycophantic champions of the U.S. government will talk about how the rigorous process that they have to go through, the rigors of the strictures put on someone seeking a FISA application, that speaks to the integrity of the court, because these restrictions that we put in place, that's what's ensuring I can't even keep going. That's what's ensuring the well-being of the American citizens' privacy, is these restrictions that are put in place that don't seem to restrict anything. What they're basically saying is that the restrictions that they have put a prior restraint on the application for FISA warrants. But we can't verify that. There's no statistical measure of how many warrants would have been sought if it wasn't such a rigorous process. And the rigorous process is largely nonsense, okay? you'll hear people talk about, and we're going to cover one of them, okay? We're going to cover one of these guys who talks about just how, just how much goes into one of these memos, that it's just unthinkable that anyone would have the ability to even do anything untoward with one of these FISA requests. I mean, there's no way this surveillance would go would go on in some sort of conspiracy land, right? Like, and we'll talk about the phrasing and the framing of this discussion in that op-ed when we get to it. But let me give a shout out to a buddy of mine who wishes to remain nameless, but he sent me this lovely bottle of a White & McKay 30. White & McKay, I don't know, 30 years. This has been an absolute treat. It's a blended scotch, which I am not normally one to look for a blended scotch. I tend to stick to the single malts. I'm not a purist by any means. My theory on scotch is what's good is good. But he sent me this. It's a lovely bottle. It's delicious. I had a toast with him last night via Skype. We had a good conversation. I really enjoyed it. And just give me a moment. It's just really good. It's got a sweetness to it. It reminds me of like a Glenfiddich, an old Glenfiddich. It's got like a nice caramel to it. It's really, it's good. And then even as I'm talking, well after that sip, sweetness is coming back up from my throat into my mouth. I enjoy it. I would strongly recommend, if you can get your hands on a sip of this stuff, to take it. It's very good. All right. So, on to the document. Now that I have sufficiently introed the heck out of the intro, let's go through this thing. All right. So, I'm going to start. There's a 2-page prefatory letter. This is from the White House to Devin Nunes. And it also CC's Paul Ryan and Adam Schiff. Adam Schiff you'll recognize from a bunch of grumpy pictures on the internet as being really mad about this and really wanting his spin on the memo to be released rather than just the Republican spin. And make no mistake, the memo is spin, okay? But that doesn't make it inherently bad or wrong or inherently good or right. And so we're gonna go through and talk about this stuff. But here we go. Dear Mr. Chairman, on January 29th, 2018, the House Permanent Select Committee on Intelligence, hereinafter the committee, voted to disclose publicly a memorandum containing classified information provided to the committee in connection with its oversight activities, the memorandum, which is attached to this letter. As provided by Clause 11G of Rule X of the House of Representatives, the committee has forwarded this memorandum to the President based on its determination that the release of the memorandum would serve the public interest. And I think it would serve some of the public's interest, right? The Constitution vests the President with the authority to protect national security secrets from disclosure. As the Supreme Court has recognized, it is the President's responsibility to classify, declassify, and control access to information bearing on our intelligence sources and methods in national defense. CEG, Department of Navy versus Egan, 1988. In order to facilitate appropriate congressional oversight, the executive branch may entrust classified information to the appropriate committees of Congress, as it has done in connection with the committee's oversight activities here. The executive branch does so on the assumption that the committee will responsibly protect such classified information consistent with the laws of the United States. The committee has now determined that the release of the memorandum would be appropriate. The executive branch, across administrations of both parties, has worked to accommodate congressional requests to declassify specific materials in the public interest. And then there's a footnote, but not really that interesting. However, public release of classified information by unilateral action of the legislative branch is extremely rare and raises significant separation of powers concerns. Accordingly, The committee's request to release the memorandum is interpreted as a request for declassification pursuant to the president's authority. So what they're saying here is we can do this. We can do this, but it's not really our place. It's the president's place to do it. But we could. So please do it. In this case, you have a favorable president, so it doesn't really matter. But it's always good for a branch of government to exert their authority where they have it, or at least remind another branch that they can, you know, we hold some strings here that you can't mess with. And if you want to know why that's important, just look at how executive action has expanded under Bush and Obama, with legislatures not fighting back against them. The president understands that the protection of our national security represents his highest obligation. Accordingly, he has directed lawyers and national security staff to assess the declassification request. Oh, and sorry, I framed this wrong. I framed that incorrect. I mean, what I said was true, but I framed it incorrectly. This letter is from the White House to Congress, and the White House there is also flexing its authority, saying, listen, we know you guys can release stuff, but it's the president's job to release stuff, and we're going to take your declassification as a request, and we're going to grant that request. Okay, so sorry to frame that incorrectly. All right. Accordingly, he has directed lawyers and national security staff to assess the declassification request consistent with established standards governing the handling of classified information, including those under Section 3.1d of Executive Order 13526. Those standards permit declassification when the public interest in disclosure outweighs any need to protect the information. And this is, you know what? I hate doing this. Let's look at when 526 Executive Order 13526. So it was issued in 2009 by Barack Obama. Let's see. I wonder if let's see. Okay. I was hoping the timing on this would have coincided with Snowden, but it was January 21st, 2009. Let's see. Freedom of Information Act. This is, I shouldn't be doing this. I shouldn't be reading this. You know, okay, so this was in 2009. This was under Obama when this was released. And I don't know off the top of my head what it's in response to, but, you know, this type of stuff, whoop, here we go. This type of stuff tends to have a reason behind it, but we'll see. If anyone is interested in finding out that reason and dropping it in the comments, please do so. That'd be neat. Those standards permit declassification when the public interest in disclosure outweighs any need to protect the information. The White House review process also included input from the Office of the Director of National Intelligence and the DOJ. Consistent with this review and these standards, the President has determined that declassification of the memorandum is appropriate. Based on this assessment and in light of the significant public interest in the memorandum, the President has authorized the declassification of it. To be clear, the memorandum reflects the judgments of its congressional authors. The President understands that oversight concerning matters related to the memorandum may be continuing. Though the circumstances leading to the declassification through this process are extraordinary, the executive branch stands ready to work with Congress to accommodate oversight requests consistent with applicable standards and processes, including the need to protect intelligence sources and methods. Sincerely, Donald F. McGahn II, counsel to the President. I love the dynastic nature of Washington, by the way. I think it'd be interesting to see, to take a look at how many juniors, seconds, thirds, fourths, or whatever there are in Washington, in government positions in Washington, and weigh that against the general population. That'd be a neat statistical study. I just wonder if you'd find people with political jobs having a massively higher distribution of seconds and thirds. It just kind of seems to be commonplace, but maybe I'm wrong. That'd be interesting to me. I find stupid things interesting though. So here is the January 18th, 2018 memo to the what is it? I forgot the acronym already. HPSCI, which is the House Permanent Select Committee on Intelligence. All right. So the subject is FISA abuses at the Department of Justice and the Federal Bureau of Investigation. Oh, excuse me. That's good stuff. All right. So purpose. This memorandum provides members an update on significant facts relating to the committee's ongoing investigation of the DOJ and the FBI and their use of the FISA court during the 2016 presidential election cycle. So this committee is investigating abuses of the national intelligence mechanism during the presidential election cycle, because there appear to have been abuses during the presidential election cycle. What's funny is, if I'm not mistaken, some outlets considered Trump's claim of being wiretapped like the lie of the year. And the best part about that is the debunking of said lie is that he wasn't wiretapped. Members of his staff were. So again, we find this with Trump where he makes a claim and they say, no, it's not this. It's this thing that's just like what you said, but not exactly what you said. And again, I am no fan. I'm not a fan of President Trump, right? Like, I don't care about him, but he is the president. And so, like, giving him a fair shake is kind of in the runnings. And for those who know me, and I know most of you don't, okay? But for those who know me will know that at the beginning of Obama's presidency, at the beginning of it, I was fervently anti-Obama, extremely conservative, very... and I'm still opposed to Obama in general, but I will go so far as to classify myself as unfair in my assessments and treatment of him in the early years. However, 8 years of growing, of education, of being pounded down by all sorts of things, changed the perspective I have on how I look at presidencies. And by the end, I actually was happy to defend him when I thought appropriate and to try and give him the fairest shake possible. I'm trying to do the same thing with Trump. They're the president. Let's defer to the powers vested in the president, who is duly elected. And let's go ahead and try to give them the fairest shake possible. Now, that's a trap for some of you, because, right, you're going to say that Trump wasn't duly elected because of any number of various reasons that are outside the scope of the Constitution and outside of our election process, and you can just deal with it. I'm sorry. There may come a time where we find out that Trump somehow stole the election. I mean, good luck. Good luck. But okay. All right. Our findings, which are detailed below. 1. Raise concerns with the legitimacy and legality of certain DOJ and FBI interactions with the FISC, the FISA court. And 2. Represent a troubling breakdown of legal processes established to protect the American people from abuses related to the FISA process. All right. So I think what I'm going to do is I'm going to go through the memo first. And then we're going to go... I'm really trying not to yawn. Sorry, I have a disability. After we go through the memo, I'm going to go through the individual statutes under which all of this authorization takes place, and we'll make just a sideline pass, right? Like shot from the bullpen. I don't know. Pick a sports analogy that I don't understand, and we'll just go ahead and you know, from the couch here, decide whether or not the definition is appropriate. Okay. On October 21st, 2016, DOJ and FBI sought and received a FISA probable cause order, not under Title VII, authorizing electronic surveillance on Carter Page from the Foreign Intelligence Surveillance Court. Page is a U.S. citizen who served as a volunteer advisor to the Trump presidential campaign. Consistent with the requirements under FISA, the application had to be first certified by the director or deputy director of the FBI. It then required the approval of the Attorney General, Deputy Attorney General, or the Senate-confirmed Assistant Attorney General for National Security Division. The FBI and DOJ obtained one initial FISA warrant targeting Carter Page and 3 renewals from the Foreign Intelligence Surveillance Court. As required by statute 50 U.S.C. 1805 D1, a FISA order on an American citizen must be renewed by the FISC every 90 days, and each renewal requires a separate finding of probable cause. Okay, so what they're saying here is you first have to have a showing of probable cause, and then each subsequent order, each renewal, has to have a separate finding, which means you have to have new evidence sufficient to support probable cause, not just the old evidence. But this is a little misleading because the statute does allow the court to consider past surveillance as part of its probable cause determination. But more on that when we get to the statutes, maybe, if I remember. Then Director James Comey signed 3 FISA applications in question on behalf of the FBI, and Deputy Director Andrew McCabe, former Deputy Director Andrew McCabe, signed 1. Then Deputy Attorney General Sally Yates, also a former employee, then Acting Deputy Attorney General Dana Boente, and Deputy Attorney General Rod Rosenstein, each signed 1 or more FISA applications on behalf of the DOJ. Now remember, it behooves us to remind everybody that Sally Yates refused to enforce the president's executive order. So when we're talking about these people who have signed this stuff, and Comey, who is an impartial paragon of justice until being fired by Trump, has now come out and blasted all sorts of people in what looked to be very partisan or slanted ways. So, you know, these positions, these people still hold political opinions. And it's not, you can't just look and say, oh, well, this is a director of the FBI. He's neutral in this. This is a political inquisition in a lot of ways. And we're going to talk about that more as we go. So due to the sensitive nature of foreign intelligence activity, FISA submissions, including renewals before the FISC, are classified. How lovely. As such, the public's confidence in the integrity of the FISA process depends on the court's ability to hold government to the highest standard. Remember what we did earlier when we went through those numbers? Remember that as we read this line, and try not to smile. Particularly as it relates to the surveillance of American citizens, which they said they didn't do for years before being shown to do exactly that. And then they said, well, we didn't try to, before being shown to do exactly that. Now we're all just resigned to the fact that they surveil American citizens based on classified warrants. Ugh. However, the FISC's rigor in protecting the rights of Americans, which is reinforced by 90-day renewals of surveillance orders, is necessarily dependent on the government's production to the court of all material and relevant facts. Read that as not some material and relevant facts. This should include information potentially favorable to the target of the FISA application that is known by the government. Not should, it must, because they don't get, you don't get to have an advocate on your side. You just have the government's side. And especially when we're talking about U.S. citizens, You need to have an advocate. And if the idea is that you don't need an advocate because, well, the government will do it for you, then they must do it. And if they don't do it, everything should be invalidated as fruit of the poisonous tree. In the case of Carter Page, the government had at least 4 independent opportunities before the Foreign Intelligence Surveillance Court to accurately provide an accounting of the relevant facts. However, our findings indicate that, as described below, material and relevant information was omitted. One, the dossier compiled by Christopher Steele. Note, a former agent of a foreign government, Christopher Steele. Again, like, if you're mad that Trump or anyone on Trump's campaign was looking for opposition research from Russian people, government officials or not, there's conflicting data on who all was an official Russian, but even if you accept all of them, Steele is a former intelligence officer for a foreign government, and Steele was contracted by the DNC and the Clinton campaign to do opposition research on Donald Trump. Like, this is like the inconsistent hypocrisy and double standard being applied to this stuff. Like, oh, well, it's okay there. Like, they paid $160,000 for information from a foreign agent. What? Like, and that's okay. But, Kushner and Trump Jr. attended a meeting in which they thought maybe they might get some information on Hillary Clinton from a Russian national, and that is honestly the biggest scandal of the year, just about, right? Like, that's treason. They should be hung. But you can go ahead and just pay outright $160,000 to a foreign agent to compile a dossier for opposition research. That's fine. Like, just think about what that is, okay? Like, so ostensibly, like, Trump and company could have just paid Russian agents for this. Like, would that have been okay? I don't know. I don't think anybody actually knows what of this is illegal. That's probably why this investigation is taking so long. Okay. Steele was a longtime FBI source who was paid over $160,000 by the DNC and Clinton campaign via the law firm Perkins Coie and research firm Fusion GPS. So they sheltered the payments because they didn't think that it was wrong to do, right? So, again, to obtain derogatory information on Donald Trump's ties to Russia. Okay. Neither the initial application on October 2016 nor any of the renewals disclose or reference the role of the DNC, Clinton campaign, or any party/campaign in funding Steele's efforts, even though the political origins of the Steele dossier were then known to senior DOJ and FBI officials. And later, we're going to get to some dork who's running for Attorney General of Illinois, who says that, well, this is not a strong argument because criminals try and get warrants overturned on this type of stuff all the time. Except criminals getting warrants overturned aren't the president of the United States, and the informant isn't funded by their political adversaries. Okay, this is a different realm of justice here. Okay, so the initial FISA application notes Steele was working for a named U.S. person, but does not name Fusion GPS and Principal Glenn Simpson, who was paid by a U.S. law firm Perkins Coie representing the DNC, even though it was known by DOJ at the time that political actors were involved with the Steele dossier. The application does not mention Steele was ultimately working on behalf of and paid by the DNC and the Clinton campaign, or that the FBI had separately authorized payments to Steele for the same information. So not only did Steele get paid by the DNC, he also got paid by the FBI. Good job. The Carter Page FISA application also cited extensively a September 23, 2016 Yahoo News article by Michael Isikoff, which focuses on Page's July 2016 trip to Moscow. This article does not corroborate the Steele dossier because it is derived from information leaked by Steele himself to Yahoo News. The Page FISA application incorrectly assesses that Steele did not directly provide information to Yahoo News. Steele has admitted in British court filings that he met with Yahoo News and several other outlets in September 2016 at the direction of Fusion GPS. Perkins Coie was aware of Steele's initial media contacts because they hosted at least one meeting in Washington, D.C. in 2016 with Steele and Fusion GPS where this matter was discussed. Steele was suspended and then terminated as an FBI source for what the FBI defines as the most serious of violations, an unauthorized disclosure to the media of his relationship with the FBI in an October 30th, 2016 Mother Jones article by David Korn. And that should give you an idea of the political slant of the dossier. I mean, if you're talking to Mother Jones, like, if you had this, flip the script and make Trump hiring someone to get dirt on Hillary Clinton, and they're talking to Breitbart or InfoWars, like you would be absurdly skeptical of this. Mother Jones is an overtly leftist publication. Steele should have been terminated for his previous undisclosed contacts with Yahoo and other news outlets in September, before the Page application was submitted to the FISC in October. But Steele improperly concealed from and lied to the FBI about those contacts. Now, this is a legal conclusion. Well, sort of. It's not really. I shouldn't say it's a legal conclusion. It's a conclusory statement. Again, I can't verify this. I can't verify that he lied to the FBI about those contacts, but maybe he did. It's in a memo to the committee. And if you made materially false representations in this memo, that would be bad, Devin Nunes. But so we have to. I hate doing this, but we presume its accuracy, its factual accuracy. Steele's numerous encounters with the media violated the cardinal rule of source handling, maintaining confidentiality, and demonstrated that Steele had become a less than reliable source for the FBI. Okay. The point of this section is that Steele should have been terminated prior to, and therefore his credibility severely diminished before the FISA court, right? Like that's this whole thing. This dossier is written by a disavowed former employee. So before and after Steele was terminated as a source, he maintained contact with DOJ via then Associate Deputy Attorney General Bruce Orr, a senior DOJ official who worked closely with DAG Yates and later Rosenstein. Shortly after the election, the FBI began interviewing Orr, documenting his communications with Steele. For example, in September 2016, Steele admitted to Orr his feelings against then-candidate Trump when Steele said he, quote, was desperate that Donald Trump not get elected and was passionate about him not being president. This clear evidence of Steele's bias was recorded by Orr at the time and subsequently in official FBI files, but not reflected on any of the Page FISA applications. So again, someone, this is bad, right? This whole thing is bad stuff because the FISA court is going to look at this and they're going to say, okay, so this dossier, in part, which we are relying to determine probable cause, is written by someone with an overt bias to not get him elected. And we have to know that if they are conducting some sort of criminal investigation, and that investigation maybe becomes public in any sort of way, or any information from that investigation is used to sway public opinion, it's devastating for the campaign. Unless you're Trump and you come out and just accuse the administration of doing exactly what they were doing, and then you can kind of use it as a bludgeon. But in reality, the idea that they're investigating a presidential campaign for collusion, it harkens back to Nixon, right? The fact that you're tampering with an election. So during the same time period, Orr's wife was employed by Fusion GPS to assist in the cultivation of opposition research on Trump. Again, as a reminder, people in the FBI and CIA and everywhere, they're just people. They have political biases and motivations just like everybody else. This is why we tend to not do political prosecutions, and including preemptive prosecutions, or at least preemptive surveillance against someone running for president, stating that they're, an agent of a foreign power without significant evidence to say they are. Okay, Orr later provided the FBI with all of his wife's Oppo research, paid for by the DNC and Clinton campaign via Fusion GPS. The Orr's relationship with Steele and Fusion GPS was inexplicably concealed from the Foreign Intelligence Surveillance Court. So again, another piece of the puzzle, and this one less so, because Orr isn't mentioned as signing any of these documents. However, he is a deputy attorney general. So, and what they're trying to do here is, okay, so if we're looking at this as a conspiracy theory, and this guy that we're going to read I'm going to go through parts of his op-ed in a little bit, looks at this as a conspiracy theory, right? These Republicans are trying to paint this as some vast conspiracy, and look how many people had to be involved to do this conspiracy. Well, yeah, you have a politicized department with a bunch of people appointed by President Obama. Then, potentially having a political motive. This isn't this doesn't need to produce criminal results to do the damage that they needed. At least they were thinking at the time. This can be a political assassination without the killing, right? By creating the specter of distrust in Donald Trump and his team, you can effectively end his chance to become president and install your successor from your own party. Something that, by the way, people have thought that Obama and Clinton had a deal for years. That they've had this deal, part of making Clinton Secretary of State. Basically, as Obama comes in and disrupts the coronation ceremony of Hillary Clinton in 2008, he promises that when he's done, he's going to do everything in his power to help her get elected president in 2016. Like it's an olive branch mending the rift in the Democratic Party following the initial Obama election. It's not nefarious or anything like that. It can become nefarious if we look at this as the Obama administration, through its appointees, goes on a political witch hunt against an upcoming opponent to their coronated successor, right? Like that's the idea. But okay. And that's the specter Nunes is raising here. He doesn't say it directly because it's not the place to say this directly, but he knows that his base and the base of the Republicans and the base of Trump in general already think these things. And they're not unreasonable thoughts, by the way. Any conspiracy theory can go on forever. But the problem with a lot of conspiracy theories, at least in this type of way, is they're just so plausible. The idea that the Obama administration would take a hands-off approach but let a bunch of its appointees basically try to engineer the election for his political successor, thus cementing his legacy as well as forwarding the Democrat platform for the next 4 to 8 years, is not out of the realm of possibility. In fact, it's an entirely likely scenario in regards to this stuff. And it probably happens more than we're comfortable admitting. But anyway. So according to the head of the FBI's Counterintelligence Division, Assistant Director Bill Priestap, corroboration of the Steele dossier was in its infancy at the time of the initial page FISA application. After Steele was terminated, a source validation report conducted by an independent unit within FBI assessed Steele's reporting as only minimally corroborated. So the stuff in the document couldn't be verified. That's what they're saying. Yet in early January 2017, Director Comey briefed President-elect Trump on a summary of the Steele dossier, even though it was, according to his June 2017 testimony, salacious and unverified. While the FISA application relied on Steele's past record of credible reporting on other unrelated matters, it ignored or concealed his anti-Trump financial and ideological motivations. So again, they're using his credibility, but ignoring the potential discredit of his motivations. And I say potential heavily because they are still potential. We don't know what the FISA court would have done had it known those motivations. But those motivations are mitigating factors. And we can't just explain them away as the FISA court definitely would have still ruled the same way. They may not have. We'll never know. It's impossible to know at this point. Furthermore, Deputy Director McCabe testified before the committee in December 2017 that no surveillance warrant would have been sought from the FISC without the Steele dossier information. And that is brutal. That is brutal. Especially because, again, when we're going to get to that op-ed in a little bit, he's going to assert that there's all this other stuff against Carter Page that says that he should definitely have had this warrant against him. And McCabe, who's Deputy Director of the FBI, says, no, we wouldn't have even done it without the dossier. The Page FISA application also mentions information regarding fellow Trump campaign advisor George Papadopoulos, but there is no evidence of any cooperation or conspiracy between Page and Papadopoulos. The Papadopoulos information triggered the opening of an FBI counterintelligence investigation in late July 2016 by FBI agent Peter Strzok. Strzok was reassigned by the special counsel's office to FBI's HR for improper text messages with his mistress, FBI attorney Lisa Page, no known relation to Carter Page, where they both demonstrated a clear bias against Trump and in favor of Clinton, whom Strzok had also investigated. So Strzok potentially had conflicts of interest in investigating Clinton and Trump, and was eventually moved ostensibly because of it, or purportedly because of it. We're taking Nunes' word on that. The Strzok-Lisa Page texts also reflect extensive discussions about the investigation, orchestrating leaks to the media. By the way, this is a crime, typically, when we have classified matters like FISA warrants. And include a meeting with Deputy Director McCabe to discuss an insurance policy against President Trump's election. So there you go. There's the Nunes Memo in all of its 4-page glory. And let's remember, though, this is a political document. At its core, it is a political document. It is not necessarily the full and complete rendering of facts. We cannot take everything in here as doctrine. We can take it as, we should accept it as true-ish, truthful and factual, but not necessarily the whole truth. Remember, Nunes is under no obligation to provide all of the factual information in here, and actually, a lot of that is still classified, even though this memo is not. So this information in regards to the Page wire surveillance is declassified, but everything else related to Carter Page's surveillance applications with FISA are still classified. So take this not as like a damning indictment of the system, but take it as what it is. It is spin in favor of President Trump by a Republican congressman. It is. There is a counter narrative by the Democrats that hilariously is not being released because they voted against releasing it. And you can take whatever approach you want as to why. Maybe they voted against releasing it because it's factually inaccurate, or maybe they just said screw you because this is a political game at this point. And by the way, if you're playing the end game of using the FISA court as a weapon against your political opponents, then don't be surprised when they use their weapons right back. I've mentioned Dan Carlin on my show a couple times, and I would love to talk to that guy in general, because he seems like an interesting fella. But he mentions that when you have these government programs, especially ones with so little oversight, or ones that are so massively complex that they become beyond the ability for the populace to question them. I think the example he uses is the IRS. But when you have these things, they have an initial purpose. And then that purpose goes on. And actually, he may have talked about FISA in general, but that purpose goes on and expands and grows because it's really useful at doing something, and it's probably really useful at something else. With the IRS, you had its creation in 1906, and then by Nixon, at the latest, by Nixon, you have it being weaponized against political opposition. Having the Foreign Intelligence Surveillance Court weaponized against your opposition is not out of the realm of history or probability. It's actually statistically likely that the longer some government program is in effect, that it'll be weaponized against your political opponent. Like it's there. It's a tempting button to push. And it absolutely is pushed frequently. The real question is, if all of this fails, like think of the implication if all of Trump's protestations fail about how he was treated by the FISA court. What do you think he's gonna do to the Democrat in the next election? Like, what do you think is gonna happen? In the next election, I'm sure the Democrat is going to be an agent of Iran, and Trump will be an agent of Russia, or maybe the Democrat will be a North Korean plant, right? Who knows? But you're playing a dangerous game of political civil Cold War, and we've got to stop this. Like, we've got to stop this because the integrity of the system isn't... it hasn't been at risk until this frenzied use of these law enforcement tools against our political opponents. And by the way, I'm the first guy to criticize Trump for one of the statements he made on the campaign trail, which made me extremely uncomfortable. When Hillary Clinton said at the debate, she said, "Thank goodness you aren't president," and Trump said, "Because you'd be in jail." Extremely worrying. Of course, it hasn't panned out that way. Extremely worrying that he would pursue a scorched earth political prosecution against his opponent. Because that's what happens in tribalistic cultures when you have an exchange of power. Then you get the exchange of vengeance, right? You get to go and exact your vengeance when you have a tyrannical sort of power structure against your political opponents. And oftentimes this was a reciprocation of civil wars or some sort of atrocity, and you create new atrocities. And then when they take back over, it's this blood cycle. We are not far away from a political blood cycle that involves the jailing of our political opponents. And that's why we don't do it, by the way. And that's why we strongly mediate and moderate discussions of prosecuting political opponents, because it's a dangerous game. And former presidents, for example, like for everybody railing against why Obama didn't pursue like some sort of war crimes charge against President Bush, because it would look highly partisan, and it might have been partisan, and partisan motivations have no place in prosecutions. And that's something we should remember. Partisan motivations have no place in prosecution. And that's the specter that Nunes is raising in this memo, and it reeks of it. It reeks of it. Outside of the context of the Nunes memo, this entire investigation into Trump for Russian collusion, which, if you'll remember, when the specter was raised that Russian collusion would influence the election for Hillary Clinton, just about everybody flew off their posts to make clear that Russians could not possibly hack the United States election. It was a foregone conclusion that Russian interference in the United States election was a thing of fantasy and myth, and in no way would Hillary Clinton's election be tainted by the idea that the Russians could influence it. And then the tables got turned, and suddenly it's the most plausible set of events that could have happened. So let's remember all of these things as we go through this. This looks still like a political hit job. And the fact that we just haven't gotten anything out of Mueller, to corroborate the idea that there's evidence of collusion, whatever that means. And if you notice, there's no articulable crime here because they don't know what crime might have been committed. They're really trying to find one. And on that note, let's start looking at the statutes here. So this is 1801. 1801 is the definitions page, and I just want to preview. There's only one relevant section for this, and I'm going to go through it in a minute. 1804A. So this is how you submit a FISA warrant request. All right. So, A, submission by federal officer. Each application for an order approving electronic surveillance under this subchapter shall be made by a federal officer in writing upon oath or affirmation to a judge. So this is under oath, penalty of perjury. Having jurisdiction under Section 1803, which is not important, of this title. Each application that just means they're a FISA judge. Each application shall require the approval of the Attorney General based upon his finding that it satisfies the criteria and requirements of such application as set forth in this subchapter. It shall include 1. The identity of the federal officer making the application. You don't get to do this anonymously. 2. The identity, if known, or description of the specific target of the electronic surveillance. Carter Page. 3. A statement of the facts and circumstances relied upon by the applicant to justify his belief that 1. The target of the electronic surveillance is a foreign power or an agent of a foreign power. And we're going to immediately go to the definition. We know Carter Page is not a foreign power because he's not a foreign government or some sort of faction. So an agent of a foreign power means that any person other than a United States person. Well, we can skip this because Carter Page is a U.S. citizen. It also includes like green card immigrants and stuff like that. To any person. Okay, so this includes Carter Page unless he's a lizard shapeshifter. That's a joke, right? Haha. Okay, any person who A, knowingly engages in clandestine intelligence gathering activities for or on behalf of a foreign power, which activities involve or may involve a violation of the criminal statutes of the United States. We don't know. We don't know what the FISA court was investigating, but they're talking about clandestine intelligence gathering on behalf of Russia, right? Like that's the idea. Or pursuant to the direction of an intelligence service or a network of a foreign power, so Russia, knowingly engages in any other clandestine intelligence activities for or on behalf of Russia, which activities involve or are about to include violation of the criminal statutes of the United States. Again, so they have to think that he fits this description. He must fit this description. Okay? C. Knowingly engages in sabotage or international terrorism or activities that are in preparation therefore or on behalf of a foreign power. So sabotage is defined right down here. Means activities that involve the violation of 105 of Title 18 or that would involve such a violation if committed against the United States. So there's a specific statutory definition of sabotage. I don't think Carter Page is accused of sabotage. Knowingly enters the United States under a false or fraudulent identity for or on behalf of a foreign power, or while in the United States knowingly assumes false or fraudulent identity. I don't think there's any allegation that Carter Page has done that. E. Knowingly aids or abets any person in the conduct of activities described in A, B, or C, or knowingly conspires to engage in the activities of A, B, or C. So basically, we have A and B are the likely suspects here, and potentially E. I don't know anything about Carter Page or his potential ties to Russians. When we get to the this piece here, is the op-ed. We'll get his take on Carter Page, and I think that's a good take because it'll be as unfavorable as possible, and we'll talk about why when we get there. Okay, so So the statement of facts and circumstances relied upon to say that Carter Page, so we have to presume that they made a factual basis that Carter Page is an agent of a foreign power as we just defined. And each of the facilities or places at which the electronic surveillance is directed or being used or is about to be used is being used or is about to be used by a foreign power or an agent of a foreign power. So everything they're surveilling has to be used by an agent of a foreign power, which would be Carter Page. Okay? So they can't surveil someone else's stuff to try and get information on Carter Page. They have to surveil only stuff that Carter Page is using. A statement of the proposed minimization procedures. What are these? Specific procedures adopted by the Attorney General that are reasonably designed in light of the purpose and technique of the particular surveillance to minimize the acquisition and retention and prohibit the dissemination of non-publicly available information concerning unconsenting United States persons consistent with the need of the United States to obtain, produce, or disseminate foreign intelligence information. Require non-publicly available information shall not be disseminated in a manner that identifies any U.S. person. Remember, I'm pretty sure these procedures were violated because Donald Trump was identified. He actually made statements about the fact that his identity was released pursuant to this memo in various leaks. So, good job. Procedures that allow for the retention and dissemination of information that is the evidence of a crime which has been, is being, or is about to be committed, and that is to be retained or disseminated for law enforcement purposes only, not political purposes. Not political purposes. No contents of any communication to which a U.S. person as party shall be disclosed, disseminated, or used for any purpose or retained for longer than 72 hours unless a court order under 1805 of this title is obtained, or unless the Attorney General demonstrates that information indicates a threat of death or seriously bodily harm to any person. So, they have to detail how they're going to accomplish those things we just talked about. I wonder what their plan was, because it seems to have failed in a couple places. A description of the nature of the information sought and the type of communications to be subject to the surveillance. That's a rubber stamp provision. Everything we want to do. A certification or certifications by the Assistant to the President for National Security Affairs. This goes high up the chain. Remember that. An executive branch official or officials designated by the President from among those executive officers employed in the area of national security or defense and appointed by the President with the advice and consent of the Senate or the Deputy Director of the FBI, if designated by the President as a certifying official, that the certifying official deems the information sought to be foreign intelligence information, that a significant purpose of the surveillance is to obtain foreign intelligence information, that such information cannot reasonably be obtained by normal investigative techniques, that designates the type of foreign intelligence information being sought according to the categories described in Section 1801E, which is here. Information that relates to and if concerning a U.S. person is necessary to the ability of the United States to protect against actual or potential attack or other grave hostile acts of a foreign power, sabotage international terrorism, or clandestine intelligence activities by an intelligence service or network of a foreign power by an agent of a foreign power. So again, they're saying that they're investigating Carter Page for Russia's attacks or clandestine intelligence gathering against the United States. Like, not just incidental communications from Carter Page to Russia. They have to, they have to talk about how these things fit into that definition. Including a statement of the basis for the certification that the information sought is the type of foreign intelligence information designated, and such information cannot reasonably be obtained by normal investigative techniques. So similar provisions to above. Number 7, a summary statement of the means by which the surveillance will be effected, and a statement whether physical entry is required to effect the surveillance. So they need to go in and bug a room, right? Like, that's the physical entry. The statement of the facts concerning all previous applications that have been made to any judge under the subchapter involving any of the persons, facilities, or places specified in the application and the action taken on the previous application. So these are for the renewals, right? Like that matters. A statement of the period of time for which the electronic surveillance is required to be maintained, and if the nature of the intelligence gathering is such that the approval of the use of electronic surveillance under this subchapter should not automatically terminate when the described type of information has first been obtained, a description of facts supporting the belief that additional information of the same type will be obtained thereafter. So then these parts are not really important. So this is just additional stuff. Personal review by the Attorney General. This is upon written request. And that's, you know, that's about it here. I'm not going to read this part. That's a lot of words to go through. But it's upon written request. Excuse me. To the Attorney General. And, you know, it doesn't matter. They didn't need to do that. That didn't happen. So it's not really relevant here. So here's 1805. This is the issuance of the order. So this is the guidance to the court of when they should issue an order granting wireless or physical surveillance. So necessary findings. Upon an application made pursuant to 1804, the judge shall enter an ex parte order as requested or as modified approving the electronic surveillance if he finds that 1. The application has been made by a federal officer and approved by the Attorney General. 2. On the basis of the facts submitted by the applicant, there is probable cause to believe that A. The target of the electronic surveillance is a foreign power or an agent of foreign power, provided that no U.S. person may be considered a foreign power or an agent of foreign power solely on the basis of activities protected by the First Amendment to the Constitution of the United States. So any protected speech, including political speech, is not a sufficient basis for this. You have to have unprotected speech, which would be speech in contemplation of a violation of U.S. statutes, basically, in this context. Each of the facilities or places at which the electronic surveillance is directed is being used or is about to be used by a foreign power or an agent of a foreign power. And, like, let's go back to that section, though. This implies that there's some sort of speech that is not protected by the First Amendment. And that is a very limited amount of speech that is not actually protected. And those unprotected speeches are actually fuzzily defined. What's interesting there is, like, the protection is broad even for contemplation in the commission of a crime. Like, you have to be extremely specific in using speech to break the law. Extremely specific. So, ignoring Carter Page and ignoring Trump, remember what I said about the statistics, right, on those reports. Do you think the court is faithfully adhering to this section? This section that requires them not to grant any of these on the basis of constitutionally protected speech. I don't think it's being honored, but that's my opinion. So, the proposed minimization procedures meet the definition of minimization procedures. Oh, excuse me. The application which has been filed contains all statements and certifications required by 1804 this titled, and if the target is a U.S. person, the certification or certifications are not clearly erroneous on the basis of the statement made under 1804 A7E of this title and any other information furnished under 1804D. Determination of probable cause. In determining whether or not probable cause exists for purposes of an order under subsection A2 of this section, a judge may consider past activities of the target as well as facts and circumstances relating to current or future activities of the target. This is a little different than probable cause in a criminal case. A little bit. These past actions aren't as... You can use them in a criminal warrant, but not so much. You need to a normal criminal warrant. You typically need to show that that they're looking at current criminal activity. not at past actions. But if someone's a known drug dealer, right, like that's a good indication that they might be drug dealing again. But anyway, so there's any minor difference. Specifications and directions of orders. So an order approving electronic surveillance shall specify the identity or description. You know, I don't know if this stuff matters. We already talked about in the memo the 90-day review. This wasn't an emergency order. So that's not really relevant. Testing doesn't really matter. And then this is a bar to legal action against the people who provide the information under the warrant. So if Verizon sells you out, you don't get to sue Verizon. But the rest of it doesn't really matter. Again, I do this not to vindicate the memo. I go through these statutes to let you know what protections are supposed to be in place for U.S. citizens, and to further let you know that they're not being faithfully honored. The fact that these orders are ex parte, and warrants are always ex parte, right? The government goes and requests a warrant. It wouldn't really make sense for the government to request a warrant to surveil or search someone and then like give them a chance to argue against it before they execute the search. That's not what we're talking about here. But what we are talking about in this case is that maybe there should be a special counsel whose sole job it is to argue the other side of these types of warrant requests, because they're so intrusive. And then the information that they collect and how they collected it is classified and is hard to challenge in a court of law following the gathering of information. It's not the type of procedure we like to see in our Justice Department. So, again, like letting you know what's in the statutes doesn't help with whether or not the FISA warrant should have been issued against Carter Page, because if we read the statutes on its face and not knowing Carter Page or much about his history, I think it'd be really hard to get a warrant against him. But I think it'd be really hard to get a warrant against a lot of people if we're faithfully executing these requirements. My point is they're not. And that means that even if they had put in the mitigating information that they should have included, it might not have changed the outcome. It's certainly not the silver bullet that it's been painted as. Okay, so last bit to go through here. This is an op-ed from Renato Mariotti. Now, who is this? Because this is usually important. Renato Mariotti, a former federal prosecutor, is a Democratic candidate for Attorney General in Illinois. So I wonder what his perspective is going to be on this, right? This isn't partisan at all. Okay. So his thesis is laid out right here. The memo doesn't vindicate Trump. It's more proof of obstruction. In my other videos, I've talked a couple times about how hard it is for a sitting president to obstruct justice. It's extremely difficult. And by the way, the case everyone cites, or like the case study for this, is Nixon, who wasn't actually impeached successfully on obstruction of justice. They had started the impeachment process. He resigned before the impeachment could take place. That does not mean that he was successfully convicted of obstructing justice. In fact, he may have been vindicated in his obstruction in the obstruction complaints had he gone through, because it's really hard for a president to obstruct justice. They have the power of the pardon, and I could talk about this over and over. All of the people who talk about this as some sort of foregone conclusion that the president has obstructed justice or can obstruct justice, just know it is an untested legal theory that the president can obstruct justice. What that even means And then know also that impeachment is a political action, not a criminal one, because they're not even sure if a sitting president can be accused of an actual crime while they're sitting. They might have to be impeached and removed first, and then criminal charges brought. We're not sure if it can happen because it just doesn't come up very often. So, yeah. So this guy, he goes on and says that release the memo. It would shake the FBI to its core. So yes, hyperbolic rhetoric was used in the release the memo campaign. Get over it. It does no such thing. The memo from House Republicans, led by Representative Nunes, fell well short of the hype. I mean, if you ask Republicans, no, it didn't. No, it didn't. This is, again, a political opinion. Its main argument is that when the Justice Department sought a warrant to wiretap former Trump advisor Carter Page, it did not reveal that Christopher Steele, the author of a controversial opposition research dossier, was funded by the Democratic National Committee and Hillary Clinton campaign through a law firm. This is a fairly so this is the first irritating part of this. This is a fairly common and rarely effective argument made by defendants who seek to suppress evidence obtained by a warrant. Well, sure, but those defendants are not presidential candidates with a political opponent funding opposition research against them. And then using that opposition research with their political party in power and their political allies in the necessary positions of power to then get a FISA warrant that could then be used to politically discredit their opponent. Like, the layers of difference between this and a drug dealer saying that Ray sold him out for some money from police as a criminal informant is way, way different. Massive differences here, okay? Like, you can't logically compare these two as some sort of congruent factual scenario. And it's really frustrating that this guy, who's a deputy attorney general, or applying to be an attorney general and is a former prosecutor, would use his authority to make a political argument under the guise of a legal comparison. They're not comparable. Let's see. Who cares about this stuff? I know I highlighted the really important section, but I'm skimming this other sections to see if there's anything useful. Oh, basically he says that since Trump approved the release of the memo, and it might make it easier for him to fire Rod Rosenstein, it could help Mueller prove that Trump fired Comey with corrupt intent. I mean, can it? Can it? Was Comey faithfully executing the duties of his office? Did he drop the investigation against Michael Flynn when told to drop it? And this may be confusing to some people, but as the boss, as the chief executive of the executive branch, right? The president is the boss of the FBI director. And if he tells him to drop an investigation, he has to do so. And then you have to get Congress to petition for someone like Mueller to come in and take over. If you don't drop if Trump says to Comey, drop the investigation, Comey has to drop the investigation. That's his job. That's why you get a special counsel to go do the investigation for you, because the special counsel reports to either an attorney general or, in this case, a deputy attorney general, as the attorney general has recused himself from the investigation for his conflict of interest in being on the campaign and being a potential witness or a potential subject of the investigation. So Rosenstein hires Mueller. Mueller goes ahead and does the investigation. Comey should have immediately stepped down and called for a special counsel. That's what he should have done. Or not stepped down, backed off of the investigation. I don't care how bad it looks for Trump, because it looks bad what he said to Comey. But it only looks bad. It's not illegal. And firing Comey for insubordination, if that's, part of his reasoning for firing him, I told him to back off the Michael Flynn thing, he didn't do it. Fired. Done. He's not executing the duties of law enforcement that President Trump has laid out. I don't know what other reasons he fired him for. It really doesn't matter. He likely had cause, or at least he could make a good case for cause. In other words, the intent to wrongfully impede the administration of justice as the law requires. This is a slanted perspective on what has happened, because it's not a wrongful imposition of the administration of justice for the president using his powers of pardon, including clemency and including a preemptive pardon, to say, leave Michael Flynn alone. He can do that. He can do that. He can also ask for loyalty, which he goes to here. Everybody makes a big deal out of this. Comey is FBI director from a previous administration who is hostile to President Trump. Asking for loyalty does not mean that there are obstruction of justice implications or anything else. It is Comey's job to faithfully execute the wishes of the President of the United States. And once President Trump is the President of the United States, he needs Comey to faithfully execute that. Trump is facing the illegal actions of states like Colorado and Washington State in legalizing marijuana. If Trump wants to flip the script on that, by the way, Comey was FBI director under Obama, who said that they would not be pursuing federal controlled substances crimes against people in Colorado or against states that legalize these things. Trump needs to know that Comey will faithfully execute it if he plans to change course. Similarly, we have sanctuary cities acting in open violation of the law. Whether you agree with their actions or not is irrelevant. They're openly violating federal immigration laws, and under the Supremacy Clause, the federal government wins on those issues. The fact that Obama chose not to enforce against sanctuary cities doesn't mean that they can't be enforced against. If President Trump decides to have his Department of Justice and his law enforcement division go after people in sanctuary cities or in other things, he needs to know that Comey will faithfully execute the jobs that he's supposed to do. Asking for loyalty is not a call to obstruct justice, and we need to stop using that because it's nonsense, and you know it. Mr. Mueller could argue that the president's comments that Mr. Rosenstein was not loyal and his desire to fire Mr. Rosenstein suggests Mr. Trump's unlawful intent when he fired Mr. Comey. Except if Mr. Rosenstein unlawfully signed off on a FISA warrant that he knew to be deficient. Then that's unloyal. That's a political assassination against Trump. And he should be fired if the basis is just a Steele dossier that's discredited. He absolutely should, because every one of these guys who signs this request or reviews it has a duty to objectively look at this. What are we doing this for? Why are we doing it? What's the basis? Is there probable cause? And at this point, I'm not entirely sure that there is, and there's a lot of evidence to suggest that these guys, that several people involved, including Rod Rosenstein, had a malicious intent in pursuing the FISA warrant. Okay. The memo also offers the outline of a broader probable cause against Mr. Page. Sort of. The Nunes Memo suggests that there was a substantial additional evidence. It doesn't suggest that there's substantial additional evidence. We just read it. It just says, it talks about, anyway, I don't even know. There's not a talk about substantial additional evidence. It avoids discussing that evidence. I think they're reading into what that substantial additional evidence may be. The memo indicates that the investigation of Mr. Page began well before the warrant under the Foreign Intelligence Surveillance Act, or FISA, was sought, and that the Russia investigation was initiated because of the statements of George Papadopoulos. Okay. So here's kind of the thrust of what he's getting at. The warrant was issued and then renewed 3 separate times. Each time, as is standard in seeking a FISA warrant, a judge reviewed extensive information. We don't actually know that it's extensive. In all honesty, we really don't know. He's making an assumption here before issuing it. And mind you, he hasn't read this either. Because as a former federal prosecutor who is, or as a former prosecutor who's seeking election as the Illinois Attorney General, he would have no reason to access this information. Like, he would not have, even if he has a security clearance sufficient to it, he doesn't necessarily have access to this information. So he's making an assumption here too. The fact that the warrant was renewed 3 times indicates that the FBI obtained useful intelligence each time. It actually doesn't indicate that at all. It simply indicates that they had sufficient differing probable cause each time. And sufficient, I'm going to use air quotes on, because what the sufficiency of that probable cause is questionable in a court where you can't review what that probable cause is. And that seems to not ever deny based on a probable cause deficiency. A judge wouldn't have approved a renewal if the prior warrant came up empty. You have no idea if that's true. Judges approve warrants all the time based on really suspect probable cause, and certainly in the FISA court they do so at an even higher rate. That suggests that once the warrants were issued, they revealed important evidence. No, that's an inference you have made. It is sort of reasonable. It is not doctrine. The memo indicates that the FISA warrants were submitted by both Obama and Trump administrations. I mean, sort of, but all by Obama appointees. The initial surveillance began before Mr. Rosenstein was Deputy Attorney General. By the time he was at the Justice Department, he approved renewal applications that were based on the intelligence gathered from the earlier surveillance, not the dossier. You don't actually know if the intelligence was gathered from the earlier surveillance or if it was something else. Probable cause does not require intelligence from the earlier surveillance in renewing the application. It just requires more probable cause evidence than was presented in the previous application. On the issue of bias, whenever the Justice Department seeks a warrant, they must present evidence, extensive evidence to a judge who decides whether to issue the warrant based on that evidence. After the fact, defendants can challenge warrants by arguing that the government recklessly excluded information that would have caused a judge not to sign the warrant. Except here, they have to challenge evidence that they don't get to see. Right? It's classified. So you get to challenge the evidence, and they get to review it lots of times without you or your attorney seeing it. And then, let's be real here, though. If this is a political assassination, which it looks like it is, the fact that, here's what's going to happen. Okay, so they improperly surveilled Carter Page because they recklessly excluded information that would have caused the judge not to sign the warrant. Let's take that, okay? But the evidence they obtain against Donald Trump from that investigation of Carter Page isn't going to be challenged by Carter Page, because Carter Page won't be charged with a crime. Okay? So it's opening a door that shouldn't be open, and the idea that they're trying to do is get far enough away from that poisonous tree to make their evidence sufficient on its own. And eventually they will. Why do you think this is taking so long? They can't just put out evidence that they get as a direct result of possibly corrupt evidence, because they can't have a corrupted chain leading there. But what they can do is gather little bits of evidence here and there through things like maybe a questionably valid warrant, and then they can use that information at a later date and say, you know what, we need a different type of warrant. We need to surveil someone else. And eventually they get far enough away from that initial bad act that the information's justified. Courts have repeatedly held that even when the government omitted the criminal history of the informant or the fact that the informant was paid, it didn't matter unless the omitted information would have caused a judge not to sign the warrant. But this isn't the same thing. This is a political case with a political operative acting in overt opposition to a political opponent. It's not just a criminal informant who gets paid for the information. This is like, there's no comparison. There's not even an analog to it in the criminal world, because in the criminal world, maybe you have drug dealers competing over turf or something, but that's not even close to this. Because, again, even the specter of the investigation is inherently damaging to the point of potentially influencing a United States election. This is not an analog to that. You can't compare them. The Nunes Memo claims to show that the warrant was obtained unlawfully. Sort of. But there is no way of knowing that without examining the extensive evidence submitted in conjunction with the warrant, which the memo does not do. But neither do you. Neither do you, which you say that this thing will be lawful, or is presumably lawful. You don't have the ability to review that extensive evidence either. So you're making an argument against the other side's ability to challenge it, but your ability to support it is similarly questionable. I just hate hypocrisy. That's why I went here. Given that Mr. Spiel was a former intelligence officer, not a flipper with an extensive criminal history, except that he's a political operative paid $160,000. By the way, criminal informants aren't paid $160,000 for their statements either. We're talking, $100, $200. This is orders of magnitude of difference. It would be hard to show that a judge would have believed he was lying if the source of his funding was included in the application. It's impossible to show what a judge would have believed. We can never know because they can't go back and not have the information that they have now. Goodness. That's the substance of this, right? I would be surprised if the memo was more than a short-lived publicity stunt. Okay. You can be surprised if it is or not. It doesn't matter. What your op-ed is here, by the way, is a short-lived publicity stunt for your election campaign running for Attorney General in Illinois as a Democrat. Like, here's the thing, guys. Here's the thing that I'm going to say it one more time and get into it. The memo is underwhelming in the fact that it's not a silver bullet. It does not necessarily show that everything would have been different if they would have made these disclosures. It was all based on the Steele dossier. It doesn't even show that it was all based on the Steele dossier. It attempts to make that case in some ways, but it doesn't fully make it because we can't see the initial FISA application. And they should really release maybe a redacted version of it. Just a suggestion. We all know that the FISA court exists now. We know it's a joke. So just release the initial application. That'd be interesting. But it's not a silver bullet. It is political spin. If you're Republican, you're probably happy about it. If you're a Democrat, you're probably not happy about it. No one is surprised by that outcome. It doesn't mean that anybody's going to go to jail for some sort of impropriety. It may give Trump grounds to fire Rod Rosenstein, and maybe he should have grounds to fire Rod Rosenstein. I don't know. It's not the best move to fire him, politically speaking, but it's still relatively early in the Trump administration. What they have to do is check and see if firing Rod Rosenstein really damages Republican election chances at the midterm, I suppose, because that's what's going to really matter. If you get a Democrat swing in the House and or both, the House and Senate would be the worst case scenario for Trump. You face impeachment no matter what anybody finds. He faces impeachment the moment that the Democrats take over. So, an impeachment again is a political tool, not a criminal tool. So, take the memo for what it is, rejoice in it, hope that this stupid memo release leads to some more transparency from FISA. Like, let's hashtag release the FISA application. We're well removed from the 2017 presidential the 2016 presidential campaign. We're well removed from that initial FISA application. Go ahead and release it. Let's see what information they used against Carter Page. Let's go ahead and find out what they're basing this off of. You know, they're declassifying all this thing. They can declassify the other stuff, redact it. If there's specific sensitive information, like maybe the names of known Russian agents or operatives, or specific dates or locations that are sensitive, go ahead and redact those. But release the memo. Let the American people see this stuff. Because this stuff is going on whether we like it or not, and it could go on against just about anybody. Like, think about how many people participate in political campaigns. So now if you volunteer unpaid on a presidential campaign, you're potentially the subject of a federal surveillance wire or wire surveillance warrant. Okay, because you talked to Russians in the past? I mean, maybe you are. Maybe you are. But anyways, let's wrap this video up. The long and short of this is, again, this is not a victory. I mean, it's a mild victory. It's a political victory in some ways. And it may give Trump the authority to fire Rosenstein. Maybe if Trump is just talking up his ability to fire Rosenstein and then doesn't follow through, that could be a big benefit for him. There's all sorts of ways they can take this. This is certainly a political victory for the Republicans. How they use it will be interesting. But let's not take it too far. Anytime you say that the FISA court might not have issued the warrant, you're deluding yourself. Because the FISA court always issues warrants. Always. Remember, 0.5% of the time, they don't. 0.5% of applications get denied. It's ridiculous. And the FISA court is a sham. It's a disgusting aspect of the U.S. court system, and the monolith that is the federal branch of law enforcement is well beyond the scope of the Fourth Amendment. Well beyond the scope of the Fourth Amendment. It's beyond the scope of the Fifth Amendment and the Sixth Amendment. Like, let's be real. It is outside of the spirit of the Constitution and the Bill of Rights. Okay? And this is a federal court, so it directly pertains to the original intent of the Bill of Rights. It's outside of Article 3 of the Constitution in its intent, if not in its text. The idea that we would have a secret court that can issue secret orders against U.S. citizens and have those orders be extremely difficult, if not impossible, to challenge is opposed to the ideas of the founding of our country. We should resist it. We should be thankful that people like Snowden reveal this stuff. And we should demand higher transparency in all of this. And as a result of this, we should definitely demand a release of the initial application, if not the subsequent 3, of Carter Page. Because it's interesting to the American public. They need to know what this political witch hunt is based off of. If it's a witch hunt or if it's a legitimate prosecution. They need to know. The U.S. populace needs to know if their election process is being meaningfully tampered by agents of a foreign power. That's in the public interest. We should release that. That should be declassified with appropriate redactions. But until it is, you can't say anything actually factual about the validity of the wire request, because presumptively they're going to grant it. 99.5% chance they're going to grant any wire request. And this one, maybe they would have changed their minds. Of course, we, in retrospect, will never be able to know, because the outcome of the events that has followed have prevented us from the ability to go back and see what would have happened. But this certainly raises some interesting questions on whether or not the FISA application is valid. And I think it plays into at least the narrative, which seems to have a degree of truth to it, that this is a political witch hunt against a political opponent from political operatives at the highest level of justice. And it looks like the Obama administration in some ways had weaponized the Justice Department against their political opponents. And by the way, we know that the Obama administration weaponized the IRS against its political opponents. That is clear. We know that in some ways they weaponized ATF against their political opponents in the gun running program Fast and Furious, selling guns to cartels, in the most short-sighted plan maybe in the history of federal law enforcement. But we know these things have happened. It is not out of any realm of possibility that a bunch of political operatives that, since this stuff started, have shown a willingness to defy President Trump, who became their boss. Open public insubordination of President Trump came from Comey, came from Yates, and in some ways came from McCabe. For sure. And those people are critical in this investigation. And some level of insubordination has come from Rod Rosenstein, although whether it's justified or not is up for debate. But Rod Rosenstein has similarly been a political actor in some of this stuff. So to say that these are like disinterested neutral parties and that this followed all the normal process of a FISA wire surveillance request is not true. This is a completely different scenario. It involves a political question that typically we would see law enforcement and we would see the federal courts stay out of, because it goes to the very heart of influencing through the specter of wrongdoing, influencing the voting populace. And for all of these people whining about how Trump is using this as some sort of political stunt, just note that it was used as a political stunt against him first. So I think I've said my piece on this. Like I said, it's not overly convincing, but it is interesting, and it raises very interesting questions. And if it's all true, and there's not a lot of mitigating circumstances that are being left out, then it certainly casts a specter of doubt. And I'm saying casts a specter a lot, but that's kind of a legal term of art in some ways. But it certainly casts a specter of doubt on the whole process, which is already a highly dubious process to begin with. So thank you for watching. I really appreciate it. I hope this video is informative to you. Hit me up in the comments if you have questions or criticisms. And yeah, y'all have a nice day. Peace.